All right, case number 22CR249, State of Ohio versus Andrew Dale Johnson. Are you Andrew Dale Johnson appearing there from the jail?
Yes, sir, Your Honor.
All right, Mr. Johnson's being represented by Attorney Catherine Hapner, who is appearing from her office, appearing on behalf of the state, Prosecuting Attorney Collins. This is a pretrial. The defendant is charged with aggravated trafficking in a fentanyl-related compound and aggravated possession of fentanyl-related compound, 5th-degree felonies. Matter is set for trial, I believe, on July 25. I have been presented with a plea of guilty form. Before I go forward with that, Ms. Hapner, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person appearance?
Yes, we are.
And that's all right with you, Mr. Johnson?
Yes, sir, Your Honor.
All right. If during this hearing you need to have a conversation with your attorney or ask her something, just tell me and I'll put the two of you in a breakout room where no one else will be able to see you or hear you, and the deputy will step out while you're consulting with your attorney, okay?
Yes, sir, Your Honor.
All right. Now, Mr. Johnson, I've been presented with a plea of guilty form, which indicates that you are going to plead guilty to count 1. I'm going to hold that up to the camera. It has your name, case number, and the plea of guilty to count 1. Do you see that page there?
Yes, sir, Your Honor.
Do you recognize it?
Yes, sir.
On page 3, there's a sentence about halfway down the page. It says, I enter this plea voluntarily. Right below that looks like a signature, Andrew Johnson. I'll hold that up to camera, and is that your signature there?
Yes, sir.
When did you sign this agreement, Mr. Johnson?
Earlier today.
All right, and when you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And did you go over this with your attorney before you signed it, and have her answer any questions, explain everything to you?
Yes, sir, Your Honor.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And you've not been rushed or pressured in any way?
No.
And are you entering into this agreement voluntarily?
Yes.
Now, the agreement, as I said, states on page 1 that you're going to plead guilty to count 1, aggravated trafficking in a fentanyl-related compound under 2925.03A1 of the Ohio Revised Code, a 5th-degree felony. And it further states that you understand that the maximum penalty for that could be 6 to 12 months in prison and a fine of $2,500 and a possible license suspension of 6 months and 5 years. Do you understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir, Your Honor.
Right now, under the law, if you're convicted of this offense and sentenced to a prison term, once you complete that prison term, the Adult Parole Authority does have the right, if they decide to exercise it, to put you under what's called post-release control for a period of up to 2 years. If they do that, you'll be supervised in the conditions they set. And if during that period of time they determine that you're not complying, they could return you to prison, make you serve an additional period of up to half of your prison term for 1 or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that offense under post-release control, in this case, to an additional period of a year, whatever time is left on the period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively, the sentence in the new case. Do you understand that?
Yes, sir.
Right now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, as most people know it. And that means that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time the probation department felt that you were non-compliant, they would file a written notice of the court. There would be a hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 12 months, fine you $2,500. Do you understand that?
Yes, sir, Your Honor.
Now, the charge in this case alleges that on or about May 31, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule II controlled substance in violation of Section 2925.03A1 of the Ohio Revised Code, a fifth-degree felony. Now, that has the penalty that I just described. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, Your Honor.
Have any threats been made to make you plead guilty here today?
No.
Now, on page 2, there are several lines that are printed in bold and underlined, and it looks like one sentence has been stricken out in ink, so because it's not going to apply, and therefore I'll read the portion that still remains. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State defense will argue sentence. Defendant agrees to pay back my money to the Highland County Task Force in the amount of $100. Defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, to pay the money back, yes, sir, Your Honor.
Anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir, Your Honor.
I'm sorry, did you say?
No, sir, Your Honor.
All right, thank you. Do you hold any license or certification from any governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have an attorney, and I appointed Ms. Hampton to represent you. That wasn't simply to work the case out, but provide any defense that might be available to you under the law that you would like her to provide. So, if you decide that you do not want to do this, that you want to defend against the charge, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Under the Constitution, you have a right to a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date, and all of them would be from Highland County. Once 12 of those people are selected, the evidence would be presented. There would be instructions of law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning it would be the judge would hear the evidence instead of a jury. The judge would decide the law, and the judge would decide whether or not the state proves your guilt. You understand that?
Yes, sir, Your Honor.
All right, now, under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, court issues a court order. It's called a subpoena, and that forces those people to come to court to be available to testify on your behalf if you want them to, even though they don't want to be present, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one will ever be able to make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element of the offense. What that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all at your trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally entered a plea of not guilty, Mr. Johnson. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in count 1 of the indictment, admits that it's a crime, and that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you today, except the right to have an attorney. You always have a right to have an attorney, no matter what you plead. But with that exception, your plea of guilty waives or gives up your right to a jury or court trial, waives or gives up your right to confront witnesses against you and to cross-examine them through your attorney, waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. Waives or gives up your privilege against self-incrimination, because if you say you're guilty, the state's not required to prove you're guilty. I'm sorry, if you say you're guilty, that is what's used to find you guilty, so it waives your privilege against self-incrimination. It waives your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. And it waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir, Your Honor.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir, Your Honor.
You understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir, Your Honor.
You understand it?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir, Your Honor.
And do you understand the guilty plea, what it means, and what the results of that will be if you enter that plea today?
Yes, sir, Your Honor.
All right, now do you need to speak to the attorney about anything before we go any further?
Yes, possibly if I could, Your Honor.
All right, go ahead and put you and her into a breakout room. It'll be just the two of you on there while we're doing that. And the deputy will step out once you're in that room, and there's going to be a button that's going to pop up that says join breakout room, and then you join that, hit on that, and then after that, when you're done, click leave meeting, then you'll have to hit rejoin meeting.
Okay.
All right, let's go off record on that one, and we'll go on record on are you Charles Lancaster appearing there from TRC?
Yes, sir.
All right, see, is Mr. Kirk there? Yes, he is. All right, we'll go ahead and take that since he's not at the jail. From it's TRC, is that correct?
TCC.
TCC, all right. His attorney is Dennis Kirk, appearing from his office, appearing on behalf of the prosecutor. Office is Prosecutor Collins. This is a final pretrial, I believe, trial set for July 8th. Mr. Lancaster is charged with 2 counts of aggravated trafficking of methamphetamine, both third-degree felonies, 2 counts of aggravated possession, also third-degree felonies. And the matter is set for trial, I believe, on July the 8th. All right, now, as far as discovery, is discovery complete?
It is from the state, Your Honor.
All right.
I believe I filed mine as well.
All right. And I see there's a motion for continuance, but other than that, are there any other motions that are pending?
No, Your Honor.
All right. And has there been a written plea agreement provided to the defendant?
Yes, Your Honor.
And Mr. Kirk, is your client aware of that?
He is aware of it, yes.
All right. And is that being rejected or accepted?
I had a conversation with him yesterday afternoon by phone, and he advised me he does not wish to reject it, but he does not wish to sign it, that he wishes to hire his own counsel to proceed in the case. And that was the basis for my filing of my motion of continuance, is we're coming up on the 2 weeks here. I believe Monday would be the 2-week limit. And so therefore, based on his request to hire his own counsel, that's why I filed that motion.
All right, Mr. Lancaster, I believe Mr. Kirk is appointed, correct?
Yes, sir.
And at the time I appointed him, you said you had no money of any type.
Yes,
You're in TRC or TCC now. What's changed that you're going to be able to hire an attorney?
It just family members.
Okay, and who are you going to hire?
I'm not sure yet.
How much are you going to have? How much are they going to pay for that attorney?
It should be the full amount. I think it was $1,500 to $2,000. I think.
Okay, that doesn't sound like a lot. So do you know who this attorney is?
I don't. I have a couple in mind, but I haven't chosen which one yet.
I see. So you think you're going to be able to hire an attorney for $1,500? I'd be surprised for a felony. I mean, here's the situation, Mr. Lancaster. We have 2 weeks, a little over 2 weeks to trial, and you have this case has been pending now since May, so it's only been a month and a half, but you were actually, I believe, you were arrested on that. So if I grant the continuance, it's going to be for a limited period of time, and it's going to be under these conditions. You're going to have to tell the attorney, that whoever the attorney is that you hire, that there is a trial date. It is absolutely written in stone. It won't be changed. Because here's the situation. I'm not going to set out a new trial date, then have you wait and have that attorney enter an appearance about a week or 10 days ahead of time, and then say, oh, Judge, I need more time. Because that's not the attorney's fault, that's your fault. So if I give you a period of time, it's going to be limited, and it's going to be written in stone. And, you're going to have to find an attorney who's willing to come in and try the case. So, so I don't like stalling, Mr. Lancaster, and I don't know if that's what this is or not. I'll give you the benefit of the doubt, but I'm not going to, put up with it. So you need to understand this is not going to go on for a long time. Ms. Collins?
Thank you, Your Honor. I just wanted to bring to the court's attention, we had a period of time when a certain individual was in the jail spreading this rumor that the state has to give 2 or 3 offers and that you get a better deal if it's an out-of-town attorney.
And that what?
You'll get a better deal if you hire an out-of-town attorney. And Mr. Lancaster was in the jail when this specific individual was in there. He's out now, so hopefully this law goes away soon. But I kind of feel like that might be what's happening here, because there was just a rash of that belief. We have to give 2 or 3 plea offers. That's the law.
So is that what's going on, Mr. Lancaster? You think you're going to get a better deal with a paid attorney?
No, sir. I was unaware of any other plea deal.
There's only one on the table, and that's been presented to you, and you haven't rejected it. So, the state doesn't just keep sending out a new offer every week. They give you an offer.
That's the only offer.
Pardon me?
That is the only offer he's getting.
Right. That's why I was explaining to him that they don't send out multiple offers. They give you one, you either accept it or reject it. Sometimes there can be negotiations for it to be, changed somewhat, but, apparently that's not the case here. So, I don't think that the plea offer is going to change. And so, if you think that's what's going to happen, I doubt it very much. And let me tell you, I was a prosecutor for 24 years, and I learned very quickly that if you give somebody a break because they get a different attorney, then everybody's going to want to get a different attorney, and the whole docket's going to explode. And I think Mrs. Collins knows that lesson too. In fact, any prosecutor worth their salt knows that. In fact, when I was prosecutor, sometimes I made it a worse deal just to make it clear to people in jail that if you want to delay this thing unnecessarily, you're going to have to pay the price. Now, Ms. Collins doesn't do that, but that was just the way I felt about it, because people were messing with the system. Now, I'll give you about a 30-day continuance. I'm going to pull a date out here in a minute, That'll be sometime in August. It'll be a drop dead date. There won't be any changes. Any attorney that comes in, you need to tell him, listen to the record of this. This will be on YouTube. He can watch a YouTube hearing where I'm telling you that if you hire an attorney, they better be able to appear for trial on that day. And if they can't, don't hire them. Because, you've got a good attorney. You don't really have a real good reason to change attorneys, I don't think. You haven't given me a good reason yet. But since it's only a month into this case, I'll give you that time. And then if it passes and you don't have an attorney, then you're going to go to a trial with Mr. Kirk. You understand?
I do. The only thing that I was looking for was to be charged with any other F3.
Well,
so
that's what plea bargaining is about, and the state's not
Yeah.
willing to do that. So,
Yeah.
doesn't matter who the attorney is, the state's the one that has to make that decision. Now, if you think another attorney might be able to sell that to him, what you're doing is, as one former now deceased attorney used to say, you pays your money and you takes your chances. If you want to pay a bunch of money to another attorney to see if they can get a better deal, I can tell you it's highly unlikely, in which case it's going to be a waste of money. You're still going to have the same charge facing you, and you'll still have to go forward to defend against that charge, whether it's a trial or if you end up pleading. So, yeah. And then the other thing is that you're kind of wishy-washy about who's going to pay and how much you're willing to pay. So,
I don't know how much money they have. That's
okay. Well, so that's my whole problem. So why am I going to think that you're going to have a different time? All right. Here's what I'm going to do. Since this case has only been pending since May, I will grant the motion to continue. Last, I'm going to put on here, no further continuances will be granted. And you need to make it clear to any attorney you talk to that, don't ask the judge for a continuance because he's going to say no. Because, you asked for this continuance, and I'm not going to let one request turn into 2 or 3 because you want to hire an attorney who can't be here on that day. So, I want it clear, you make it clear to them that that's what the situation is. All right, so this case is set for July the 8th. I will continue this for trial until August 15 at 8 a.m. Final pretrial will be July 17 at 1 p.m. That will be in person. All right. So that's what you tell your attorney. And I'm telling you, don't hire an attorney that says, well, I'll go in and ask the judge because you'll have to give me a continuance. Because I don't. Because I made it clear to you. You're the defendant.
Yes,
and if you decide, if you wait till 2 weeks before your family comes up with the money for an attorney 2 weeks before, that attorney better be ready to try the case. Because if they're not, then, they're not going to, they shouldn't take the case, number one. And if they do, then they're just going to have to try it on 2 weeks' notice. And that'll be your problem, not theirs. They're going to say, well, it won't be able to be effective. And I'm going to say, you know what? You're probably right. But guess whose fault it is? It's your client's. And so understand that. Now, Mr. Kirk is still your attorney until you hire an attorney. And that attorney enters an appearance in this case in writing. Once that person does it, then he'll no longer be your attorney. But until that happens, if it happens, he's going to be your attorney. All right? Do you have any questions?
don't.
Good. I'll try to make myself clear. All right. Anything further from counsel?
No, Your Honor.
All right.
Hey, Your Honor.
All right, Ms. Hapner, are we ready to go forward then?
We are, yes.
All right. I don't think I asked you this, or if I did, I've forgotten. Are you a U.S. citizen, Mr. Johnson?
Yes, sir, Your Honor.
All right. Do you have any more questions about anything that we talked about?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to count 1 pursuant to the terms of the plea agreement we just went over?
Yes, sir, Your Honor.
All right, then as to the charge of count 1, which alleges that on or about May 31, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule II controlled substance in violation, Section 2925.03A1, a charge of aggravated trafficking of fentanyl-related compound, a fifth-degree felony, carrying a possible prison term between 6 and 12 months, and a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same. Pursuant to Criminal Rule 11, the pleas accept an order filed. Defendant is found guilty of count 1. Count 2 is dismissed. Court will order a pre-sentence investigation that shall include an assessment for substance use disorder and/or mental health treatment possibilities. Sentencing hearing will be set for July 10 at 9 a.m. All right, is there anything further from counsel?
Yes, Your Honor. Can we address the issue of bond?
Yes.
Now that Mr. Johnson has pled guilty, and we do ask that he be granted an OR bond at this point. He has informed me this morning that he does still have a job, his job at Arresti, if he can get back to work in the next day or two. He's used up all his vacation and sick time during his incarceration. So we do believe that it would be beneficial for everybody if he could get back to work. He does live in Wilmington, so he is fairly local, and I did emphasize to him that if he is granted an OR bond, or if he makes bond, that the importance of making it to his scheduled court times.
All right, Ms. Collins.
Thank you, Your Honor. We would object to any reduction in bond. Would note that Mr. Johnson is here. He failed to appear at his plea hearing. Clear back in on July 14th of 2023. Prior to that, he had failed to appear at a hearing because he had drove himself to a treatment facility somewhere and was likely under the influence of something, if the court recalls. Additionally, I spoke with one of the officers that actually arrested Mr. Johnson on this warrant. My understanding is there was like a standoff. They had to go into the house and physically get him. He was not coming out, something to that effect. So even though he was just in Clinton County, I can tell you he was trying to avoid Highland County because we worked with several people to try to get him down here to get him arrested over the last year. So I would object to any reduction in his bond.
Refresh my memory. I'm thinking that Mr. Johnson may have had a warrant for absconding from community control when he was in drug court. Am I correct in that?
Well, I think he was in drug court when we did this.
Yes, but I think there was this charge wasn't brought for a little while, but I know he was in drug court, was terminated and sent to prison, and I was thinking that there was a failure to, there was either an absconding or a failure to report for court.
That's
I know
correct.
he was in a couple of times for hearings, so, well, be that as it may, regardless of whether that's a correct recollection or not, the fact that you've been released originally on this case, Mr. Johnson, had failed to appear, I'm not going to give you an OR bond because it took almost a year to get you, and we're not going to take another year to get you if you don't show up again. So bond will remain the same. All right. Anything further from counsel?
No, Your Honor.
Your Honor.
All right. Thank you. All right.
Can you hear me?
All right. Case number 24-CR-008 and 23-CR-163, State of Ohio versus Robin Robinson. Are you Robin Robinson appearing there from the Recovery Council?
Yes, I am.
All right. This is a sentencing hearing being conducted by Zoom. The defendant entered a plea of guilty in case number 24-CR-008 to failure to appear, and in 23-CR-163 to illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, third-degree felony. Court referred the matter for a pre-sentence report, which I have received and reviewed, and have each of the attorneys had an opportunity to review a summary.
I have, Your Honor.
All right, Ms. Collins, on behalf of the state.
Only what's contained within the plea agreement, Your Honor.
Ms. Collins, or Ms. Hapner?
Thank you, Your Honor. We would ask that you follow the plea agreement for community control. My understanding is that Robin has been doing well at the Recovery Council. She's been actively participating and has tested negative and is making good progress. So we do believe that she is a good candidate for community control. She is taking her recovery seriously, and we ask you to follow the plea agreement.
All right, Ms. Robinson, anything you'd like to say?
That I'm just doing well, and I'm doing better things.
All right. Well, it is the order of the court then that the defendant be sentenced in each case to a term of 3 years of community control under the following conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your supervision conditions. You must report when and as directed as well. You must keep your supervising officer informed of your residence, place, employment at all times, may not change either without prior permission. Not to leave the state of Ohio at any time without prior written permission. You're not to enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior permission. Now, because of your conviction, you're prohibited from, in 23-CR-16, actually both for right now, you're not permitted to purchase, possess, use, or have under your control any firearm, ammunition, or dangerous ordnance. And it's a condition you not have any of those or any other weapons while you're on community control as well. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance has effects similar to those unless you have a legal prescription. This also applies to any instruments, devices, or things that may be used to administer them or prepare them for administration. You must also have a legal prescription for those items as well. And you must provide those within 24 hours of receipt to the probation department. You must submit to drug testing when and as directed. You're not to purchase, possess, use, or have under your control any kind of an alcoholic beverage, nor may be present in places where the sold being consumed even if it's otherwise lawful. You're not to associate with any co-defendant, nor with any other person who has criminal records, a member of a gang, or any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. That applies to any family member that falls within that definition. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any conviction, arrest, citation, or other charge of violating the law or any other contact with law enforcement not later than the next business day after that occurs. Must provide your supervising officer financial information records so your ability to pay any restitution fees or costs can be reviewed. You'll be required to, if they are referred by probation or by TRC for an evaluation or assessment for further any kind of further treatment, therapy, counseling, training, programming, etc., you'll submit to that. If there's a recommendation for any kind of programming, you're to enroll in and follow that in your dependence of this action. You'll be required to do 4.5 hours community service and be given credit for each hour you worked. In an hourly rate set by the court, each hour you work, reduce your judgment by that amount until paid in full. Be required to successfully complete your substance use disorder, abbreviated SUD, in your entry. residential treatment, as well as any aftercare at TRC, which is recovery counseling. And aftercare means that once you're done with the residential program, what they recommend you should do. Now, they can't make you do it because you're not in custody. So if they say, here's what you should do, you say, no, thank you, that's going to be a violation because I've already told you you're going to do what they suggest. That's no longer in your decision, in your control. That decision's been made. Now, by being placed under community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your vehicle, your residence, or any other property or place that's under your control or where you're found at any time by any officer of the probation department. Now, in the event that it's, you're deemed to have consented to a search without a warrant of your property. I said that, I guess. In the event that the probation department feels that you're not compliant, they will file a written notice up in the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then your community control can be terminated. In case number 23 CR 163, you could be sentenced to a term of between 9 and 36 months in prison and a fine of $10,000. And in 24 CR 008, you'll be fined to a period of 6 to 18 months and a fine of $5,000, and those could be ordered to be served consecutively. Now, in the event that you do serve a prison term, once you complete that term, it is possible that the Adult Parole Authority may exercise the option to put you under post-release control supervision for a period of up to 5 years. If they do, you'll be supervised by the probation or by the parole officer in the terms they set. And if during that period of time they determine that you have not complied, then they can return you to prison and make you serve an additional period of up to 9 months for one violation, up to a maximum of half your prison term for all violations. However, if you commit a new felony, then in addition, whatever sentence can be imposed in the new case, the judge can also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence of the new case. All right. Is there anything further from counsel?
No, Your Honor. No, Your Honor.
All right. Just keep in touch with the probation department then. Mr. Robinson, thank you. All right. State versus Jeffrey Everhart. Case number 24 CR 76, State of Ohio versus Jeffrey D. Everhart. Are you Jeffrey D. Everhart?
Yes.
All right. It says the second on your jacket, but only but not in the indictment. Are you a second or just regular Jeffrey D. Everhart?
I'm a second.
All right. So you're one and the same. All right. Now, this is a pretrial being conducted by Zoom. Mr. Everhart's appearing from the Justice Center. His attorney is Jeffrey Blosser, appearing from his office, appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged in a 15-count indictment with various trafficking and possession charges, as well as having a weapon under disability. This is a first pretrial, actually a final pretrial, and trial is set for July 11th. All right. Now, where do we stand on this case, counsel?
Your Honor, we've continued negotiations. Actually, I just returned Mr. Blosser's email during the last hearing, so I think that we will be setting this for a plea.
Mr. Blosser?
I would agree with that. I was able to convey, in addition, that a small change that Mr. Everhart had requested that I do. I believe we've accomplished that. I know that today was the day for the offer to remain open. However, I may not be able to see him to get him signed up until this weekend.
Okay. Well, that'd be all right. We can do it next week, Monday or Tuesday.
Okay.
And if you want to do a Zoom, it's easier for you to do a Zoom. And Mr. Everhart's in agreement with that. We'll do it that way.
Yes, sir.
All right. So we'll hold the
I'll
jury
advise.
notices until Monday. And if we can get it scheduled Monday, or even if we have to do it Tuesday, we can hold off a day or so.
Certainly.
All right. Anything further?
Thank you.
Then? All right. Thank you.
Thank you.
All right. Rufus Brummer, please. Brummer.
get it right.
All right, oh, he's on his way.
Your Honor, he's here at the probation department, not jail.
Oh, he is?
Yes, sir.
Okay, we have
Posted
him in
bond,
here,
Judge.
being in jail. All right.
Posted bond.
Pardon me?
He posted his bond.
Okay, I see that. All right, you're Mr. Baker then, or I'm sorry, Mr. Brummett at the probation department?
Yes, sir.
All right, this is case number 24 CR 64, State of Ohio versus Rufus Lee Brummett. Hold on a second. The jail, are you still in the room there, Deputy?
Yes.
All right, then let's get Miriam Vanderpool and then Ms. Trader after that.
Okay.
Thank you. All right. Mr. Brummett's attorney is Anthony Baker, and prosecuting attorney Collins appearing on behalf of the state. Everyone's appearing by Zoom. This is the first pretrial. Mr. Brummett was indicted for 3 counts of rape, a first-degree felony, and final pretrial. Actually, this is the final pretrial. We have a trial set for July 22nd, I believe is what that says. I can't read my writing. All right. So is discovery complete?
Not on my end, Your Honor.
Pardon me?
Not on my end. I have not replied to the state's request yet.
Okay, well, that is supposed to be done by today.
I know. I apologize.
All right.
I had
Go ahead.
I had obligations to Adams County that I didn't know were jury trials that went that I didn't think were going to go.
Okay.
And that's where I've been. And then a vacation that had been pre-planned, I returned it a day early to do this.
All right. Well, if you could get it done, then I'll extend that deadline to Monday, as well as any pre-trial motions. Now, has your client accepted or rejected the written plea offer?
He hasn't either accepted or rejected it yet. It was provided by the state, I believe, on the day of the initial pretrial we had on the 5th. So my plan was to go back over things with him, and he can accept or reject it.
Okay. Well, we have, the 14-day rule here, and your trial date's the 22nd, I believe, so that would be July the 8th would be the deadline to have any agreement put on record, and that's a Monday, and I think we actually have a jury trial set that day, but I don't know, maybe we won't after we get done today, but anyway, we'd work it in if we have to, and if not, then we'll look at this going to trial then on the 22nd. All right, anything?
I can make myself available any day next week too, Your Honor.
All right, well, if you do get something resolved, just give us a call, we'll work it in, so.
Yes, sir.
All right, anything further, counsel?
No, Your Honor.
All right, thank you.
Thank you.
Case number 22 Sierra 191, State of Ohio versus Miriam Ruth Vanderpool. This is a video pre-trial. She's appearing from the jail. Her attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. The defendant is charged in a 5-count indictment, grand theft, receiving, possessing criminal tools, 2 drug-related charges. Ms. Collins has the alleged victim of counts 1 and/or 2 been notified of the time, place, and purposes hearing the right to be heard?
We have advised the 6:20 hearing they will not be attending.
All right. All right, final pretrial on this is set for July 17. August 12 is the trial date. I see that the state provided discovery. You received that, Mr. Kirk?
I have, Your Honor.
All right, well, your discovery is due by the final pretrial. Do you anticipate any pretrial motions?
And not at this time.
All right, well, if you do determine there's any to be filed, they'll be done due by the final pretrial. Has there been a written plea offer received?
There has.
Your client aware of it?
I did make her aware of it, yes.
All right. All right, are there any other matters then that need to be discussed at this time?
Your Honor, I was wondering if we could add a 10% provision to my bail, so we could pay 10% due to court, common police court?
I don't do 10%.
You do not?
I don't.
All right, thank you.
All right. All right, thank you. All right, Allison Trader, please.
Rager.
All right. And we'll need Mr. Holland in after this.
Okay.
All right, case number 24 CR 41, State of Ohio versus Allison E. Trader. Are you Allison E. Trader appearing there for the jail?
Yes, sir.
All right, this is a pretrial being conducted by Zoom. Ms. Trader is appearing from the Justice Center. Her attorney is Dennis Kirk, appearing from his office. Appearing on behalf of the state is Prosecuting Attorney Collins. The defendant is charged with 3 counts of trafficking in different substances and 3 counts of possession, a mixture of 3rd and 4th degree felonies. I believe this is a first pretrial, and
Your Honor, this is the final pretrial.
oh, it is a final pretrial. All right. When is this matter set for trial then? July 8th, looks like. All right. Okay, so where do we stand on this case?
Your Honor, you have a plea form.
Okay. Oh, here it is. All right, didn't realize it was there. Okay. So, Mr. Trader, I have a plea of guilty form here with your case number and name. It says you're going to plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.0381, a 3rd degree felony. I'll hold that first page up to the camera and ask you if you recognize it.
Yes, sir.
You do?
Yes.
All right, and on page 3, about a quarter of the way down the page, there's a sentence that reads, I enter this plea voluntarily, and right below that appears to be a signature, Allison Trader. Is that your signature?
Yes, sir.
When did you sign this?
Monday?
All right, and when you signed it, did you understand it was an agreement to plead guilty, which means it won't be a plea, the next step will be a sentencing hearing?
Yes, sir.
And did you go over this with your attorney and have him explain everything to you and answer any questions before you signed it?
Yes, sir.
And when you signed it, you understood it was going to be an agreement to plead guilty?
Yes, sir.
Do you feel you've been rushed or pressured in any way into doing this?
No, sir.
Right now, the agreement states, let me back up. Did you sign this agreement voluntarily?
Yes.
And are you going forward today voluntarily?
Yes.
All right, the agreement states you're going to plead guilty to the charge in count 1, as I indicated, which is a 3rd degree felony. And it states that you understand that the possible sentence for that could be anywhere from 9 to 36 months in certain increments provided by law, and a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, I thought that I had agreed to 24 months.
Well, it's not what you agreed to, it's what the maximum is. I'll get to that in a minute.
Oh, okay, yes.
The maximum possible penalty is between 9 and 36 months. You understand that?
Yes.
All right. Now, are you facing any felony charges anywhere else?
No.
Are you currently on probation, parole, community control, or post-release control for a felony?
Yes, I'm on Fayette County probation.
All right. And what type of charge is that? Is that a felony?
Yes, sir.
All right. And so, under the law, if you are convicted of this offense, then that could be considered to be a violation of that community control. And if you are charged with violating that because of this conviction, then it's possible you could be sentenced to prison for that offense, and then it could be consecutive to the sentence in this case. Do you understand that?
Yes, sir.
right? Now, under the law, this is not a mandatory prison term. There is a possibility of community control or probation, which means instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. And if during that period of time, the probation department felt that you were non-compliant, they would file a written notice of the court. There would be a hearing. The outcome of that hearing was that you'd failed to comply. Then at that time, the court could revoke your community control and then sentence you to the 9 to 36 months and fine you $10,000. Do you understand that?
Yes, sir.
And again, just as I indicated earlier, if you were revoked in part or in whole because of conviction of another felony offense and were sentenced to prison for that, that term could be ordered to be served consecutively as a prison term here. Do you understand that?
Yes, sir.
All right, now the charge in this case alleges that on or about April 28, 2023 in this county, you did knowingly sell or offer to sell methamphetamine, a Schedule I controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1. So that's the charge with the penalties I just described. Do you understand that charge, what the state said you did, when, where, and how they allege you did it?
Yes, sir.
And you, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty?
No.
Now, on page 2, there's several lines printed in bold and underlined which contain the plea agreement, which I think you were referring to a moment ago. So I'll read that at this time. It says, defendant will enter a plea of guilty to count 1. State will dismiss remaining counts. State and defense jointly recommend 24 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force in the amount of $600. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Ms. Trader, the matter of sentence is up to the judge, not the parties. And so even though there's a joint recommendation from both parties as to what the sentence should be, if you plead guilty, I don't have to follow that. I could decide that that's not the proper sentence and impose any sentence between the 9 and 36 months, fine you $10,000, and maximum fine of a mandatory fine of $5,000, and suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
Now, you have certain rights you must understand before I can accept your plea. First, you have a right to have counsel, and I appointed Mr. Kirk to represent you. Now, that appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So if you decide that you do not want to do this, that you would rather defend against the case, he'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once 12 of those people are selected, and all those, again, will be in Highland County, the evidence will be presented, they'd be instructed on the law, and then the jury of 12 would have to decide by unanimous verdict, meaning they would all have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing your right to have a jury trial, and then you would have what's called a court or bench trial, which means instead of a jury hearing the evidence, it would be the judge would hear the evidence, apply the law, and decide whether or not the state proves your guilt. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. That means that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present in front of the jury. After the prosecutor's done asking questions, your attorney asks questions, which is called cross-examination. The purpose of that is to try to bring out evidence that might help your side of the case. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify in this proceeding at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's up to you. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person. No one can even comment about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't upon you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally entered plea of not guilty plea, denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime, and that plea gives up all of the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty gives up your right to a jury or court trial, gives up your right to confront witnesses against you, to cross-examine through your attorney, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. The gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. The gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you are sentenced to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
Are you a U.S. citizen, Ms. Trader?
Yes, sir.
Now, do you have any questions about the offense or the possible penalties?
No.
You understand it?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation on the sentence is not binding on the judge?
Yes, sir.
Do you have any questions about the constitutional rights?
No, sir.
You understand them?
Yes, sir.
Have any questions about the plea of guilty? What it means? What will happen if you enter that plea here today?
No.
You understand?
Yes, sir.
Is there anything you need to speak to your attorney about before we go any further?
No, sir.
I believe I forgot to get this on record, but Mr. Kirk, you and your client are both in agreement to conduct this matter by Zoom rather than in person.
Yes, Your Honor, we are.
And you're all right with that, Ms. Trader?
Yes, sir.
Okay. Now, do you have any questions you need to speak with your attorney about? If you do, I can put you and him into a breakout room for two of you to confer privately.
No, sir. I'm good.
Okay. You have any questions at all?
No, sir.
And then it's your decision to withdraw your not guilty plea, plead guilty to count one pursuant to the term of this plea agreement.
Yes.
Okay. Then as to the charge which alleges that on or about April 28, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, violation of Section 2925.0381 of the Ohio Revised Code. Charge of aggravated trafficking in methamphetamine, a third-degree felony, carrying a possible prison term between 9 and 36 months in increments provided by law. Fine of $10,000, mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendant is found guilty of count 1. Counts 2 through 6 are dismissed. The matter will be, sentencing will take place forthwith, since there is an agreed recommended term. All right, Ms. Collins, on behalf of the state.
Thank you, Your Honor. We would ask the court to follow the joint recommendation as outlined in the plea agreement. Would note that Ms. Trader has a substantial prior criminal history and additionally was on I believe is on community control right now out of Fayette County for a felony charge. So based on all that, we would ask the court to impose the agreed upon sentence. Thank you.
Mr. Kirk, on behalf of the defendant.
Thank you, Your Honor. Would ask the court to follow the joint plea agreement. In this case, my client has owned up to her involvement in the indictment and has resolved the matter without a trial or any of those resources being needed. So would ask the court to consider that and grant the plea as outlined.
Anything you'd like to say, Ms. Trader?
No, sir.
You were arrested, as I see here from the records, on May the 13th. Is that correct?
Yes, sir.
All right. All right, then it is the judgment order of the court. The defendant being is hereby sentenced to a term of incarceration at the Ohio State Reformatory for Women in Marysville, Ohio, for a period of 24 months. The defendant is given jail time credit of 38 days. Now, upon completion of this prison term, Ms. Trader, the Adult Parole Authority may exercise the option to put you under post-release control for a period of up to 2 years. If they do, you'll be supervised in the terms they set. If during that period of time they determine that you've not complied, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum total of half of your prison term for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence could be ordered served in that new case by that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater, if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, because judge grant execution order. If you fail to do that, then the court could order you to do community service once you complete your prison term, not while you're in prison, and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. You're also ordered to make restitution in the amount of $600 to the Highland County Task Force. That will be payable through the Highland County Victim Witness restitution escrow account, and you'll pay any fees associated with that for that service. All right, is there anything further from counsel?
Mandatory fine, did I miss that?
Has there been any change in your financial circumstances since I appointed Mr. Kirk to represent you, Mr. Trader?
What is, I'm sorry?
Has your financial situation changed since you were arrested on this charge?
Oh, no, sir.
All right, the court will then find that the defendant does not have the ability to pay, nor will she likely in the near future be able to pay the mandatory fine, and therefore it's waived. All right, you're remanded to custody. Thank you. Kyle Hollins, next, please.
Okay.
All right, we have case number 24 CR 75, State of Ohio versus Kyle A. Holland. And this is a pretrial on that charge, which is set for a jury trial on July 22nd as a final pretrial. And you're Kyle Allen Holland appearing there from the jail?
Yes.
All right, Mr. Holland's attorney is Jacob Wagner, appearing from his office. Appearing on behalf of the state is Prosecuting Attorney Hollins. The defendant is charged in a 4-count indictment, 2 counts of aggravated trafficking of methamphetamine in the vicinity of the school zone, and 2 counts of aggravated possession. Mr. Holland, I have received a plea of guilty form here that says you're going to plead guilty to, looks like, count 1 and amended count 3. Now, before we go forward, Mr. Wagner, are you and your client both in agreement this matter can be considered by Zoom and heard by Zoom rather than an in-person occurrence in the courtroom?
Yes, sir, Your Honor. I had it on mute. Apologize.
All right, and you're okay with that, Mr. Holland?
Yes.
All right. Now, we're going to hold the first page of this up. which says, this agreement says you're going to plead guilty to count 1, aggravated trafficking of methamphetamine in the vicinity of the school zone under 2925.03A1, a second degree felony, and amended count 3, which currently is also trafficking of methamphetamine in the vicinity of the school zone, a second degree felony. It's going to be amended down 1 degree, same offense, except to delete the school zone, which makes it a third degree felony. I'm going to hold this up to the camera, this first page, and ask you if you recognize that form.
Yes.
And on page 3, there's actually 4, there's a sentence at the top of the page. It reads, I enter this plea voluntarily. And right below that, there is a signature that appears to be Kyle Holland. I'll hold that up to the camera and ask you if that is your signature.
Yes.
When did you sign this agreement, Mr. Holland?
Today.
And when you signed it, did you understand that it's an agreement to plead guilty, which means that there won't be a trial? The next step in your case would be a sentencing hearing?
Yes.
And did you go over this with your attorney, have him explain everything to you before you signed it?
Yes.
And do you feel that you had enough time to fully consider the matter before making the decision?
Yes.
Did you do this voluntarily?
Yes.
And this is still what you want to do?
Yes.
All right, now, the law, or the agreement states that you understand that on count 1, the penalty for that is 2 to 8 years as imposed by the judge, which is a mandatory term, meaning it all has to be served. And it could be extended by half of whatever the judge imposes by the DRC, which means that if the 8 years was imposed, the maximum could be extended. It could be extended up to 12. If the minimum of 2 years is imposed, it could be extended by a year up to 3, and everything in between. You understand that?
Yes.
All right, and there's a fine possible of $15,000, a mandatory fine of $7,500, a license suspension of 6 months to 5 years. You understand all that?
Yes.
And again, you understand, on count 1, whatever sentence I impose has to be served. No
Yes.
early release of any time.
Yeah.
Now, and then that could be extended by the Department of Rehabilitation and Corrections by half. And then any sentence that is served on that charge, if you're sentenced to prison on count 3 as well, that would be served could be served consecutively, meaning on top of. And so that sentence is 9 to 36 months. So the maximum 36 months could be added to the 8-year maximum on count 1. So that makes that, if you convert 36 months to years, that's 3. So that makes the maximum minimum possible of 11 years with a maximum of 15 years and a fine of $25,000. Do you understand that?
Yes.
Other than these charges, are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
Yes.
Where's that?
Highland County.
Well, that's right. Yeah, I have that file here. Okay, in that case, 22 CR 214, you are on community control since March 3rd of 2023 for aggravated possession of a fentanyl-related compound. All right, and it looks, you were put on community control on March 8th, 2023. I see the alleged offense in these cases are November 16 and 17. So, if you're convicted of the counts 1 and 3 in this case, under your conditions of community control in the other case, that would be a violation of those rules and would subject you to being having that revoked and being sentenced to a term on top of the term in this case of between 9 and 36 months. You understand that?
Yes.
That would be added on top, so 3 years would be added on top of the 11 to 15. So you could be looking at somewhere between 14 to 18 years. You understand that?
Yes.
Right. Now, under the law, in case number 24 CR 75, if you're convicted, you will be sentenced to a prison term. You have to serve that. It's mandatory. And upon completion of that term and any other term that you're serving, you will be required under, for the offense of count 1 to be put under post-release control supervision for at least 18 months. It could be up to a maximum of 3 years. On the other 2 charges, it's optional, and that's up to 2 years. But on count 1 in 24 CR 75, it's mandatory, so you will be supervised by a parole officer on a term set by the adult parole authority. And if they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control supervision, then in addition to any sentence that could be imposed for that offense, the judge in that case could sentence you to an additional term for committing that while under post-release control in this case, to a period of 1 year, whatever time is left on the period of post-release control, in this case, whichever is greater. And if that occurs, that would have to be served consecutively the sentence of the new case. Do you understand that?
Yeah.
All right. Now, charge in this case in count 1 alleges that on or about November 16, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding bulk amount less than 5 times bulk amount in the vicinity of a school zone, in violation of 2925.03A1. So that's the mandatory prison term of second-degree felony in count 1. Count 3, by deleting the allegation that was committed in the vicinity of the school zone, reduces that by 1 degree. So the language would read the same, except the vicinity of the school zone would be out. The date of the offense is alleged is November 17. Otherwise, it's the same offense, but the sentence is on between 9 and 36 months in the increments provided by law, which is not mandatory, and a fine of $10,000. And a license suspension of 6 months to 5 years. Now, do you understand what it is you're charged with in those 2 counts, including count 3 as amended? What the state said you did, when, where, and how they alleged you did it?
Yes.
We discussed the nature of the charge, evidence in the case, possible legal issues in the case, and possible defenses you might try to raise in trial, and possible outcomes of a trial with your attorney.
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Now, on page 2 of your agreement at 24 CR 75, there are several lines printed in bold and underlined that I'll read as follows. Defendant shall enter a plea of guilty to count 1 and count 3 is amended to a felony of the 3rd degree by removing the language offense was committed in the vicinity of a school zone. State will dismiss remaining counts. State and defense jointly recommend 2 years mandatory incarceration on count 1, consecutive to 24 months incarceration on count 3, to be served consecutively to the term of incarceration imposed in case number 22 CR 214, which is your community control case you're on now. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money an amount of $210 to the task force. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter of sentence is up to the court, not the parties. So if you decide to plead guilty, the court's not bound by that recommendation. So I could give you the maximum sentence, which I explained earlier. Could be 14 to 18 years, plus the fines and license suspension. You understand that?
Yes.
Now, do you hold any professional license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
All right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel, and Mr. Wagner was appointed to represent you, not simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So if you decide you do not want to do this, that you'd rather defend against the charge, he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes.
Right? Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are residing in Highland County that are summoned for your jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law. And then that jury would then decide whether or not the state proved your guilt by proof beyond a reasonable doubt on either of the charges. And that verdict would have to be unanimous, meaning all 12 would have to agree as to each. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial, and in that case, you would have what's called a quarter bench trial, meaning instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify against you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request court issues a court order called a subpoena, and that forces those people to come to court to be available to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is that the burden of proof isn't upon you to try to show that you're not guilty of this offense. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, originally you entered a plea of not guilty. The not guilty plea denied the allegation of both counts of the indictment, denied you committed any crime, and exercised or revoked all the rights I've just described. Now, if you change your plea today from not guilty to count 1 and guilty to count 3 as amended, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment of those 2 counts as amended, admits that they're a crime, that you committed those crimes, and that plea waiver gives up all the rights I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but without accepting your plea of guilty would waiver give up your right to a jury or court trial, waiver give up your right to confront witnesses against you and cross-examine through your attorney, waiver give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state, would waiver give up your privilege against self-incrimination because if you say you're guilty, the state's not required to prove you're guilty. Waiver gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Also subjects you to being sentenced immediately by the court, which was likely to happen. And as I said, it would also result in your being found to be in violation of your community control 22 CR 214 and facing an additional penalty of 9 to 36 months, fine of $10,000, and a license suspension of 6 months to 5 years in that case as well. You understand all that?
Yes.
Now, plea of guilty would also subject you to being sentenced immediately by the court, which likely would happen, and it would also waive any right to file an appeal you think you could have had up until this point in the case. If you are sentenced to the maximum sentence or under certain circumstances, you can file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes.
Are you a U.S. citizen?
Yes.
Now, do you have any questions about the plea or the consequences? I'm sorry, any questions about the charges or the possible penalties or consequences?
No.
And you understand it?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
And again, you understand the matter of sentence is not binding on the court?
Yes.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yeah.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand it?
Yes.
Is there anything you need to speak to your attorney about before we go any further? If so, I can put you and him into a breakout room.
No.
You have any questions at all?
No, not at the moment.
This is your decision to withdraw your not guilty plea, plead guilty to count 1 and amend to count 3 pursuant to the terms of the plea agreement that we've just gone over.
Yes.
I'm sorry?
Yes.
All right. Then as to count 1, which alleges that on or about November 16, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding bulk amount less than 5 times bulk amount in the vicinity of the school zone, in violation of Section 2925.03A1 of Ohio Revised Code, a second-degree felony, carrying a mandatory prison term of at least 2 years, up to a maximum of 8 is ordered by the judge with the possibility of an additional 1/2 of any sentence imposed by the court being added by DRC. A fine of $15,000, a mandatory fine of $7,500, and a possible license suspension from 6 months to 5 years. How do you plead?
Guilty.
And as to amended count 3, which alleges on or about November 17, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount less than 5 times bulk amount, a third-degree felony as amended, carrying a possible penalty between 9 and 36 months, a fine of $10,000, mandatory fine of $5,000, a possible license suspension from 6 months to 5 years. How do you plead?
Guilty.
And you also do that with the understanding that those two pleas will result in you being found to have violated your community control in case number 22 CR 214, which will result in revocation of that and sentence being imposed as more likely than not to be run consecutively?
Yes.
Okay. All right. How do you plead then?
Guilty.
Okay. All right. The court finds that on this day in open court, the defendant was advised of all his constitutional rights, made no intelligent voluntary the waiver of the same pursuant to criminal 11. Pleas accepted, order filed. Defendants found guilty of count 1 and amended count 3. Counts 2 and 4 are dismissed. Now, inasmuch as count 1 is a mandatory prison term, the defendant is on probation in another case and has violated those conditions, the court will go ahead and proceed with sentencing. Ms. Collins, on behalf of the state.
Thank you, Your Honor. We would ask the court to follow the joint recommendation as outlined in the plea agreement.
I need it on this other case too, Dan. Is there anything in there on this other case? 214 case. All right. Yeah. Mr. Wagner, anything you'd like to say?
Only I would ask the court to follow the recommendation. I didn't do the first case with Kyle, but at least with my case, Your Honor, he's been nothing but pure respectful to me. I mean, I'm not much of a defense in this case. He admitted he was caught red-handed in this. We just asked the court, obviously, to follow the recommendation, any leniency possible in the probation violation, Your Honor.
Mr. Holland, anything you'd like to say?
No, Your Honor.
All right. Now then, in case number 22 CR 75, it is the order of the court that the defendant be sentenced on count 1 to a mandatory term of 2 years as a minimum, which could be extended by the Department of Rehabilitation Corrections to up to 3 years. As to count 3, it's ordered to be sentenced to a term of 24 months. Those sentences are ordered to be served consecutively to one another for a period of 4 years. In case number 22 CR 214, the court finds that the defendant's conviction has resulted in his violation of the terms of that order, granting him community control, which prohibited him from being convicted of a new offense, and therefore and that's a 4th-degree felony, not a 3rd-degree felony, I should say. Therefore, he is terminated from community control in that case and sentenced to a term of 6 months. He's also ordered to pay, and that is also ordered to be served consecutively to the sentence in the 24 CR 75 case. The court will find that these offenses were committed at least in 24 CR 75 as a course of continuing conduct, and with regard to 22 CR 214, it's a separate course of conduct, and that one single prison term will not adequately reflect the seriousness of the offenses, and the term being imposed being a minimum, and 2 of the 3 counts is not disproportionate to the seriousness of the offense. Also, the court will find that the offenses in 24 CR 75 were committed while the defendant was on community control in 22 CR 214. And finally, his criminal history demonstrates that consecutive sentences are necessary to protect the public. Now, according to the sheriff, in case number 24 CR 75, you were arrested on May the 10th. Is that correct, Mr.
Yes.
Holland? All right, so that would be, as of today, 44 days. Don't have a jail time credit. Up here it comes on the other case. So in 22 CR 214, it looks like you got 1 day credit on that. All right. Now, you're also ordered to pay the court cost for which judgment is granted and execution is ordered. And if you do not make those payments or make arrangements to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, then upon completion of your prison term, not while in prison, upon completion, the court can permit you to do community service, give you credit for each hour you work. And a 9-hour rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. You're also ordered in case number 24 CR 75 to pay restitution in the amount of $210 to the Huntington County Task Force, and that will be payable through the victim witness restitution escrow account. You'll pay the service fees required for that service. It's also you're also informed, Mr. Holland, as I indicated earlier, that upon completion of your prison term in 24 CR 75, on count 1, you'll be required to be under post-release control for a period of at least 18 months up to a maximum of 3 years, which means you'll be supervised by a parole officer of the terms that the adult parole authority sets. And if they determine that you have not complied with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you should commit a new felony, then in addition, whatever sentence could be imposed by the judge in the new case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater, if that occurs, that must be served consecutively as sentence in the new case. All right, is there anything further from counsel?
Did you have something, Mr. Wagner?
No, I was going to say not from defense counsel.
Just the fine again.
All right, the fine. Have you had any financial changes since you were before me and I appointed Mr. Wagner to represent you?
No.
All right, then the court waived the mandatory fine with regard to count 1 and 24 CR 75. All right, you're remanded in custody. Probation department. All right, this is case number 24 CR 47. State of Ohio versus Tiffany L. Watson Bating House. Appearing on behalf of the state, Assistant Prosecuting Attorney Adam King. Appearing on behalf of the defendant's attorney William Parker. And are you Tiffany L. Watson Bating House?
Yes, Your Honor.
All right, Ms. Bating House is under plea of guilty to count 2 of disseminating matter harmful to juvenile, and count 5, endangering children, and that is a third-degree felony. The court ordered a pre-sentence report, and I did receive that. Have each of the attorneys had an opportunity to review the summary?
State has, Your Honor. Yes, Your Honor.
All right, now Mr. King, has the victim or the representative of the victim been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, and the representatives are present here in the courtroom today.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation as outlined in the plea agreement The victim's representative, Jim West, is present here in the courtroom today and would like to make a statement if the court would permit.
All right, Mr. West. Go ahead and just state your name for the record.
Jim West.
Go ahead.
I'm Jim West. I'm grandfather of the victim and her brother. And this has been rough on all of us. I retired from my job in September of 22 to help my family on the farm. And in February, we got a phone call, we got to come get the kids, or they'll go to foster care, which there was no way we was going to let that happen because we love them kids. And we've done everything we could for these kids, and they ask for her almost every day. The little one, we're going on vacation here in a week or two, and he wanted to know if we could take Mommy with him. And we just say, well, we can't right now, maybe later. And they both love her. We still love her. They want her back in their lives, and we want her back in our lives. And they're both, the victim, she's going to counseling, and we've also started her brother, 6-year-old brother, he's going to counseling too, because he's having a hard time understanding. We believe she's a victim too, because she was never allowed to tell Andrew no. I mean, he laid the law down and they had to follow it. And we hope that she can get counseling when she goes in to wherever she's going. Because she was a good mom. She still is. I know she loves them kids. And I just thank the court for letting me get up here and talk, and I do appreciate her accepting responsibility, and so the victim doesn't have to get up here and testify, because it would break her heart. And that's anything else? Yeah. But that's all I got to say. Thank you for letting me speak.
Thank you. Anything else, Mr.?
That's all, Your Honor.
Mr. Parker?
Thank you, Your Honor. Your Honor, I would start by saying that, counsel has handled well over 100, probably 200 or 300 child endangering cases, both as defense counsel and as a prosecutor. And I sincerely stand before this court and say this may be the first child endangering case that I've ever handled on either side, Your Honor, where I don't think there was any malicious intent. Miss Watson-Battinghouse made a series of extremely poor parenting decisions. She's taken responsibility for that. She's not running from it. But I'll echo Mr. West, that she sincerely loves her children. She was placed in a position where it's not in every parenting handbook as to how you handle that. And she realizes that she handled it the wrong way. She has to be responsible for her actions, and she's taken responsibility and has taken responsibility by pleading multiple felony counts, and she understands a prison term given the jointly recommended sentence is likely. So based upon the unique circumstances of the case, Your Honor, the victim input, and everything else in this case, we'd ask the court consider adopting the jointly recommended sentence.
All right. You go by Watson, right?
Yes, sir.
Ms. Watson, is there anything that you would like to say?
Just that I'm sorry, Your Honor.
Well, this is a very disturbing case. Because the victim of the offense was your daughter, and I'm not surprised that she loves you, and I believe that you love her. But that's not unusual in a situation where there's abuse in the home. And in this case, you weren't inflicting abuse yourself, but you violated your duty as a parent to your child and your children. Mr. Parker's right. There's no handbook when we have children that says this is how you do it. Now, there's lots of books out there. You can read them. But here's the bottom line. I don't think you have to be taught that you are to protect your child. I think that the maternal instinct, particularly to protect a child, is inherent in giving birth. I don't see any evidence that you do not understand right from wrong, or that you don't understand that. Now, the fact that you were apparently married to a brute who dominated you, I understand that. There's a lot of marriages and relationships out there like that. I deal with them all the time. But a person has to be willing to protect their children. Their lives came before yours, and you surrendered that. And from what I read, you not only surrendered it, but you more or less went along with it and enabled it. The very first time you could have done something about it and left. Called your family, called the law, gone to children's services, gone to a woman's shelter, gone to domestic alternatives to violence. There was lots of options available to you, and you chose the most despicable option, silence, and allowed this to continue. And so that's the problem with this case. And your children have suffered, and your family suffered, because they're not only assuming the childhood, the duties of rearing your children in your absence, but also dealing with the fallout with your daughter's counseling, and that's got to be very difficult. And your sons wanting you to be around and not understanding why you can't be, and that's hard for them too. It breaks their hearts, I'm sure. It breaks anybody's heart that when something like that happens. But you have no one to blame but yourself. And you can say that it was a bad decision. Well, to me, bad decision is a mistake where you have a couple options and you think about it and you decide, well, this is the best one and I'll do this, and you turn out to be wrong. In this case, there was never any doubt what the right thing to do was. There was never any doubt. Protect your child. And you failed. And so that's the problem that is inherent in this case. And so it is a judgment of the order of the court that with regard to count 2, that you be sentenced to a term of 12 months incarceration at the Ohio State Reformatory for Women in Marysville, Ohio. And on count 5, to a term of 18 months. Those sentences are ordered to be served consecutively to one another. The court finds that these are two different types of harm, and while they were committed as a series of misconduct, they are differing offenses with differing types of harm, and the court finds that one single sentence would not adequately reflect the seriousness of the offense, and the sentence being imposed is not disproportionate to the seriousness of the offense, being a mid-range a sentence in each case. And the court feels that this is necessary for the protection of the public and your children. Now, according to the sheriff, you were arrested on the 12th of March and released, looks like on the 14th, is that correct? 2 days?
Yes, Your Honor.
All right. So you'll be given 2 days of jail time credit. All right, now, upon completion of this sentence, if you serve the entire term, and that is a possibility, the adult parole authority could place you under post-release control and supervision for a period of up to 2 years. Oh, wait a minute. Is count two that's not considered a sex offense?
No, Your
No, it's
Honor.
not subject to registration.
No, Your Honor.
All right, so up to 2 years optional. They don't have to, but they can. And if they do, you'll be supervised under terms that they set by a parole officer. And if during that period of time they determine that you have not complied, they will have the right to return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new offense while under post-release control, new felony offense, and are sentenced to prison for that offense, the judge in that case could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively with the sentence in the new case. You're also ordered to pay the court costs, which judge granted execution's ordered. If you fail to do that, the costs can be collected by the clerk by various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the prison term, not while you're in prison, once you get out, you can be permitted to do community service in this county and be given credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
No, Your Honor.
All right, you're remanded to custody. Counsel, would you approach? Not on record yet. All right, case number 24, CR 77, State of Ohio versus Jeffrey Wade Duncan. Mr. Duncan is appearing by video from the probation department. His attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. The defendant is charged with 2 counts of aggravated trafficking and 2 counts of aggravated possession of methamphetamine. I have a plea agreement form here. Now, Mr. Kirk, are you and your client both in agreement that he can appear by video rather than in person?
Yes, Your Honor.
And you're all right with that, Mr. Duncan?
Yes.
All right, if at any time during this hearing you need to talk to your attorney, since you're not seated in the courtroom, you just tell us, and then I'll put you in a breakout room where only the 2 of you will be able to see each other and hear each other, okay?
Okay.
You need. I don't need you for anything else. Are you waiting on something else? Yeah, but we're going to defer him. Yeah, so you can go ahead and go. Thank you.
Thank you.
All right. Now, I have this plea agreement in front of me, Mr. Duncan, which says you're going to plead guilty to counts 1 and 3. I'm going to hold this up to you. The camera has your name and case number. It says you're going to plead guilty there to counts 1 and 3. You see that?
Yes.
And on page 3, there are a sentence. There's a line halfway down. It says, I enter this plea voluntarily. It looks like right below that is a signature, Jeff Duncan. And is that your signature?
Yes.
When did you sign this, Mr. Duncan?
This morning.
When you signed it, did you understand it was agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And did you go over this with your attorney before you signed it?
Yes.
And do you feel you had enough time to fully consider the matter before making the decision?
Yes.
You don't feel you were rushed or pressured in any way?
No.
And you signed this agreement voluntarily?
Yes.
And you're going forward with it now voluntarily?
Yes.
All right, now, as I indicated, it says you're going to plead guilty to counts 1 and 3. Count 1 is aggravated trafficking of methamphetamine in violation of section 2925.03A1 of the Ohio Revised Code, a 4th-degree felony. Count 3 is the same offense, same section, but it's a 3rd-degree felony because of the additional allegation that I'll go over with you here in a moment. States that you understand that the possible prison term on count 1 is 6 to 18 months with a fine of $5,000 and a possible license suspension of 6 months to 5 years. Count 3 is 9 to 36 months with a maximum fine of $10,000 and a mandatory fine of $5,000 and a license suspension of 6 months to 5 years. You understand that?
Yes.
Now, if you are convicted of both offenses and sentenced to prison on both, terms could be ordered to be served consecutively to one another, meaning one after the other. So that means that the maximum penalty count 1 is 18 months, the maximum on count 3 is 36 months, so that means a total maximum of 54 months, a maximum fine of $15,000. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No.
Now, under the law, if you should be convicted of these offenses and sentenced to prison, once you complete that term, it is possible the Adult Parole Authority would put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the terms they set, and if they determine that you've not complied, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum cap of half of whatever prison term was imposed for all violations. But if you commit a new felony, then in addition, whatever sentence a judge in that new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence of the new case. You understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison. I could impose what's called community control or probation, meaning instead of going to prison, you'd be put under supervision of a probation department under terms set by the court for a period of up to 5 years. And if during that period of time they determine you have not complied, in their opinion, they would have to file a written allegation of that with the court, give you a copy. There would be a hearing, at which time you would be entitled to have an attorney, and if the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for the 54 months and fine you $15,000. And if you were revoked because you have been convicted of another felony offense while under community control, then any prison term that was imposed for that offense could be ordered to be served consecutive to this offense, or these sentences. Do you understand that?
Yes.
Right now, count 1 alleges that on or about January 14, 2024 in Highland County, Ohio, you did knowingly sell, offer, sell, I'm sorry, it's count 1. Yeah. Methamphetamine Schedule 2 controlled substance, in violation of section 2925.03A1. So that's the 4th-degree felony. And then count 3 alleges that on or about January 16, 2024 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance amount equal to or exceeding bulk amount, but less than 5 times bulk amount in violation of the same statute. It's the same offense, but that one's a 3rd-degree felony because of the additional amount that's allegedly involved. And so that makes the penalty greater, as I explained earlier. Now, Mr. Duncan, do you understand what you've been charged with in each of those cases, what the state said you did, when, where, and how they alleged you did it?
Yes.
And you understand the possible penalties for each?
Yes.
And have you discussed those charges, the evidence in the case, the possible legal issues in the case, the possible defense you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty here today?
No.
Now, the agreement states on page 2, there are several lines printed in bold and underlined that I'll read now. Defendant will enter plea of guilty to count 1 and count 3. The state will dismiss remaining counts. State and defense jointly recommend 9 months incarceration on count 1, consecutive 24 months incarceration on count 3. State will not oppose judicial release to substance abuse treatment after 6 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay my money to the task force in the amount of $160. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the court, not the parties. And so even though there's an agreement as to what the sentence should be, that is not binding on the court. And so if you plead guilty, once I've heard all the information, if I decide that's not the appropriate sentence, I could impose a sentence of up to 54 months and fine you $15,000 and suspend your license for 6 months to 5 years. You understand that?
Yes.
Same thing holds true with judicial release, Mr. Duncan. If you file for judicial release, just because the state says they're not opposed to it, doesn't mean that it'll be granted. The judge is still the one who makes that decision. And if you present the information and I determine that it's not appropriate, I could deny that. Do you understand that?
Yes.
All right, the lights just went out on you. Is your room
Yeah,
dark over there?
No. I can get up and try to turn them on.
There's no lights in the building? Oh, there we go.
Oh, there it is. Come back on.
All right.
They go off because nobody moves for a long time.
Oh, okay. All right. Well, it means you got to get up and move around, so. All right. Now, you have certain constitutional, well, let me back up. Do you hold any license or certificate from any state governmental agency that regulates any occupation or profession?
No.
Now, you have certain constitutional rights you must understand before I can accept a plea. First, you have a right to counsel, and Mr. Kirk was appointed to represent you. That appointment isn't simply to work the case out, but to provide whatever defense may be available to you under the law that you would like him to provide. So if you decide you don't want to plead guilty, that you want to defend against the case, he will continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes.
Right now, under the Constitution, you have a right to have a jury trial in this matter, which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and that jury of 12 would then decide by unanimous verdict, meaning all 12 would have to agree on each count as to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. You understand that?
Yes.
Now, excuse me, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes.
All right, now under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request court will issue court orders called a subpoena. And that would force those people to come to court to be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes.
All right, now under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, judge can't, it's up to you. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about that, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you're presumed innocent of these offenses until proven guilty by the state of Ohio on every essential element of each offense. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally entered the plea of not guilty. Mr. Mr. Duncan, your plea of not guilty denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits it's a crime, you committed that crime. And that plea waives and gives up all the rights I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty waives and gives up your right to a jury or court trial, waives and gives up your right to confront witnesses against you and to cross-examine through your attorney, waives and gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Waives and gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. Waives and gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It waives and gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to maximum sentence or under the certain circumstances, an appeal can be filed. That would have to be filed within 30 days of your entry of sentencing being filed. And it also subjects you to being sentenced immediately by the court. Do you understand all of that?
Yes.
All right. And are you a U.S. citizen?
Yes.
All right. And you're going forward today voluntarily?
Yes.
All right. Do you have any questions about either the charges or the possible penalties?
No.
You understand them?
Yes.
You have any questions about the plea of guilty, what it means, or what will happen if you enter that plea?
No.
And you understand that the recommendation on sentencing is not binding on the court?
Yes.
And do you have any questions about the constitutional rights I explained?
No.
You understand those?
Yes.
Is there anything you need to speak with your attorney about before we need to go any further? Because if you do, I can put you and him into a breakout room.
No.
Have any questions at all?
No.
Is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 3 pursuant to the terms of the agreement that we just went over?
Yes.
All right, then, as to count 1, which alleges that on or about January 14, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Ohio Revised Code, charge of aggravated trafficking of methamphetamine, a 4th-degree felony, carrying a possible penalty of 6 to 18 months in prison, a fine of $5,000, license suspension for 6 months to 5 years. How do you plead?
Guilty.
As to count 3, which alleges that on or about January 16, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.03A1, a 3rd-degree felony, with a possible sentence between 9 and 36 months, fine of $10,000, mandatory fine of $5,000, and possible license suspension for 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendants advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept that order filed. Defendants found guilty of counts 1 and 3, counts 2 and 4 are dismissed. I'm going to order a pre-sentence report in this case since there's a potential for a judicial release hearing. I'm going to refer the matter to the probation department for that, and that's to include an assessment for substance use disorder, mental health issues, and bond will be continued. And sentencing will be set for August 7 at 9 a.m. All right, is there anything further from counsel?
No, Your Honor.
All right, you'll be here in person on August the 7th at 9 a.m., Mr. Duncan, okay?
All right.
All right. Mr. Arjima, why I've still got you on the screen, and Ms. Sturgill, I don't know why it's never occurred to me until this point, but you folks over there don't have the assignment notices we give out in court for defendants, do you? I don't believe you do. Do they, Mr. Strait?
Sometimes.
Well, what I want to do is have the bailiff, next time somebody's over here, pick up a stack of those. So when we do plea hearings like this, you can have them sign, write it in, so whoever's monitoring from probation, and give it to them so we can put that in the file. We do that for anything that's in front of in court here with the bailiffs, but for probation, when we do the Zoom hearings, I just thought about it as we were going through here. Believe it or not, my mind still thinks on other tracks when I'm talking, professional requirements. You can talk and think about something else at the same time. But anyway, it occurred to me we've never done that. So next time you're over here, somebody will get a stack. Give about 20 or so.
Yes, sir.
Yeah, okay. So we can do that. All right. All right, so see the probation department then, Mr. Duncan. Thank you.
All right, thank you.
All right, Riley Richards, is he there, probation? For the record, we have case number 24 CR 54, State versus Jason Bond. I neglected to call that earlier. His attorney is Catherine Hapner. Their record will note that there is a warrant out for his arrest for leaving, I believe he left treatment and violated pre-trial. Looking here for that. He was due to be here today at 1 o'clock. Yeah, the court revoked his bond on May 14th. No, instead of hearing on May 22nd, he did not appear. Well, in that case, yeah, we do have a bond. I mean, we do have a warrant, do we? I'm looking here for the entry. I thought we did. And actually, William Armitrout's his attorney. I forgot. Ms. Hapner was had to recuse or had to withdraw due to a conflict. I'm just looking here at the file. All right, since he didn't appear on the 22nd, I believe we issued a warrant at that time. But I don't see any entry in here. Oh yeah, here it is. Capes was issued, his hearing to be held May 22nd, and he wasn't here for that either. All right, okay, we got it. All right. 24 CR 55, State of Ohio versus Riley Logan Richards. Are you Riley Logan Richards appearing there from the probation department?
Yes.
All right, Mr. Richards is charged with burglary, safe cracking, and grand theft. His attorney is Jacob Wagner. It's being conducted by Zoom. Mr. Richards is appearing from probation department. Attorney Mr. Wagner is appearing from his office. Prosecutor Collins is appearing on behalf of the state from her office. This is a final pretrial trial is set for July 8th. Ms. Collins, has the alleged victim or victims of these offenses been notified of the time, place, and purpose of this hearing?
They have, Your Honor. They have, Your Honor, and they advise that they'll watch the YouTube live stream, but they are not going to attend.
All right. All right, this matter is set for July 8th. Where we stand on the case, counsel?
Ms. Collins, may I?
Yes.
Your Honor, I'll take a lot of this delay, only because I was gone all last week. Right, I had this already signed. We've asked the court, I filed, I don't know if you got it or not, for a continue to the July 8th trial. We've agreed to a stipulated polygraph. The state's given me the form. I have that. I need to go over it with Riley and get it submitted to the court. I don't know if I could do that here in the next couple of days and get it in front of you first of next week, but just, I think obviously the polygraph's going to be dispositive one way or the other, Your Honor.
Ms. Collins?
And this is a case that hasn't been pending long. I haven't had an opportunity to check with the victim to see if they object, but they've been extremely understanding of the system so far, so I anticipate that they would not object to a continuance.
All right. Well, the indictment in this case was returned on April the 2nd, so it hasn't been pending but a little over 2 months in this court. And since polygraph, I think would be, if it's going to be dispositive, would be beneficial to both parties as well as the alleged victims, since it would go a long way in determining what the outcome of the case is. So I will grant the continuance. Mr. Have you got a date, possible date yet, Ms. Collins?
I do, Amy, if I may.
Yeah.
Yes.
I apologize. I'm looking at it right now. It's July 2nd at 8:30.
All right. Well, we need to get a hearing set up on this, so as soon as you get Mr. Richard's signature, if you can get it over here, and we'll try to do a real quick hearing by Zoom If you can get it just faxed over to the prosecutor or emailed to the prosecutor in the court, we can do it while he's at your office.
Yes, sir.
All right, so I will.
Riley, are you free to come up? I apologize. Riley, are you free to come to my office right now?
Yeah.
Come on up here and we'll get this, go over and get to the prosecutor as soon as possible.
All right, sounds good.
All right, 112. All right, bud.
All right.
Thank you, Your Honor.
You go ahead and take off then, there, Mr. And head to his office, and we'll keep the hearing open. And then as far as a possible date, I'll be looking at, I don't have the calendar in front of me. July 25th would be the day of trial.
Yes, sir.
All right. I'm going to take a moment break here while he's walking over there. You get him to sign that, and then when you're ready, come back on the screen. And we'll leave this session open.
But I'm done with Mr. Richards though, right, Your Honor? Or you want to do the stipulation now?
Do you have the form there for him to sign?
I've got the form.
Well, I thought if you could get him to sign it, and either fax or email it over to me. And has Ms. Collins already signed it, or somebody in their office?
No.
She is not, Your Honor.
Okay.
He hasn't had a chance to go over it with them either. He just got it.
All right, well then we'll just wait then. We'll go ahead and end the session then. Yeah.
Thanks, sir.
All right, thank you.
Thank you.
All right.